Welcome to the National Liberal Club. What a great venue to be at today, and thank you to them for hosting us. Welcome on behalf of A.C.T National Limited. I'm the MD of A.C.T. My name is Phil Atkinson, and we've moved quite a few mountains to get a crack legal team here today to give you an experience of what being in an actual courtroom is like. We'd also like to thank Aon. Aon are insurance brokers. I'm sure most of you will know of them. We are a risk partner to Aon, and we provide services to their clients to help them reduce their overall cost of risk. So Aon and ourselves are a key partner, and we're very pleased to have them here today. This case that we're going to hear today, if it was actually at trial, will probably take 3 days, a minimum of 3 days. We're going to try and cover that in a day. So that will mean that some parts of it will be abbreviated, but what will happen is David and the rest of the legal team will break out and we'll talk to you and tell you why that's happening and what the salient legal points are and why they've asked a certain question, or if we've abbreviated a section, why that's been abbreviated. So, in terms of the legal team, I thought I'd better do a bit of Googling when we assembled the legal team, so I could do a bit of a bio for each of the barristers that we have with us today. David, who's our prosecution barrister for the day. David was called to the bar in 1992. He's worked as an advisor to Chief Constable of Devon and Cornwall Police and has prosecuted and defended many health and safety cases. He works these days advising businesses and governments in terms of their exposure to these kinds of cases, and we're very pleased to have him with us. David will be the linchpin for the day and will be effectively guiding us through the course of events. Richard on my left. Richard will be the case for the defence. Richard was previously a HSE inspector before he became a lawyer, so he's uniquely placed to use his skills and knowledge of prosecutions to make sure his clients achieve the best possible defence from a HSE perspective. So we're very honoured to have Richard with us as well. And finally we have our judge for the day, Ian Ross. Ian's an independent barrister and has prosecuted for more than 15 years before moving into the regulation of professional qualifications and organisations. He also sits as a judge and is involved in the training of advocates, so I think we've got a first-class team here. You'll also meet throughout the course of the day, I won't go through them all individually, but we have various members of the A.C.T team who have been press-ganged into playing parts within the case today. So they will play various roles as witnesses and as the accused throughout the course of the day. So you'll meet them as the case goes on. The scenario that you will have in your packs is an everyday incident. It's something that could occur in any incident. It's actually based on a real incident, and Dave will probably say more about that in due course. It's an everyday case of working at height and the relationships between contractors and clients. So that's all I'm going to say. It will be an interesting case, but bear in mind it's based on real events, real evidence, and the real outcome. Maybe we'll have a different outcome today, who knows, we're going to prejudge that. So I'm now going to hand over to David, who's going to commence with proceedings and say a few words. Thank you, David.
Morning, everybody. Morning. This must be a rarity for you, actually listening to some lawyers today and not being charged for it. First of all, thank you all for coming. We hope you enjoy the day, but as Phil just indicated, it's nothing without you. We will try to bring a certain informal formality about today's proceedings, but what we want is for you to engage with us and to ask questions and to, if appropriate, raise matters which may be of your concern, although we can't give you legal advice because you'd sue us if we got it wrong. We are here to help you. Can I first of all ask us, who here has actually ever been in a court? And is that professionally or as a defendant?
A witness.
Well, courts, as you know, there are different types of them. Although we're dealing with health and safety here today, they are dealt with in the criminal courts. But if, for example, there is a fatality, as you may know, there will be 3 courts probably involved. Firstly, the coroner's court. Then, if appropriate, the criminal courts, be it a magistrate's court or a crown court. And then, at the end of it, possibly a civil court, where there'll be proper claims for compensation on behalf of the injured party or the deceased family. Now, Today we're going to concentrate upon the criminal procedure and the investigation. As you heard, Richard here used to be a health and safety investigator, so please grill him. Please ask questions as to how he would approach investigations. He also worked as a risk consultant for the Atomic Energy Authority before he decided to go totally over to the dark side and become a solicitor because he realised there was more money in it. He's based over in Bristol. Ian here is based all over. Ian is an immigration judge, also a tribunal judge in relation to social entitlement, also an assessor for the General Dental Council, and also part and parcel of an advisory team who deal with the regulation of accountants. And so, from his perspective, as to how people give evidence, as to how people approach coming to courts, again, feel free to ask him questions. There'll be a certain amount of hamming up, because it is supposed to be fun. Please no heckling, especially I noticed most of you came in and sat at the front to show your desire to engage. Some of you went straight to the back and we've got your eyes on you straight away. We just hope that those of you sat at the front don't end up gravitating towards the back as the day goes on. You've got in front of you a set of papers. As Phil indicated, it is based upon a real case which occurred last year. You, no doubt, most of you will deal with having to engage subcontractors. If I can give you a little flavour as to what happened, and if no doubt when you read the papers you'll think, why on earth would someone use this sort of documentation? Why on earth did they do that? Well, the client company who engaged subcontractors had turnovers in excess of £35 million. But their main work was in the hospitality industry. They also, however, had petrol stations because it's Devon after all. And they used the health and safety advisor, who would normally help them with the hotels, to deal with a construction project at a petrol station. They used documentation which they would use in relation to performing hospitality functions and slight amendments to accommodations for a serious construction project in relation to a petrol station which was kept open during the construction work. So, yes, these things happen. People are foolish. Because no doubt when you realise you're going to be meeting lawyers, you probably thought to yourself, well, why do we need lawyers? In our experience, one of the problems we face when we're dealing with cases is we're coming to things after the event. And a lot of reasons why people end up being prosecuted, or fatalities occur, or serious injuries occur, is because of human error. But when you're facing an investigation by the Health and Safety Executive or the Environment Agency or whatever, you are out of your comfort zone. Your core business is making money dealing with whatever you do. Our core business is looking after people. And hindsight is a wonderful tool which so many people who we come across wish they'd had more of. But the reality of the situation is that if you get the systems in place, if you have the knowledge base amongst your employees and amongst your staff, then not only can you ensure that there can be zero harm to those who work, but also if, God forbid, something does happen, the Health and Safety Executive are in the position to properly decide whether it was an accident or whether actually there was some culpability. Now, the whole regime in relation to health and safety law has changed, not in relation to what the law and how it applies, but into the way in which it's prosecuted, because since the austerity programme began from central government, the Health and Safety Executive, along with other arms of the prosecutorial agencies, are able to recoup their costs. And that has become a major factor into why people are prosecuted. Whereas in the past, people would often get away with a warning. Now, if there is a fatality, you will be prosecuted. If there is serious injury, you will be prosecuted more than likely, even if it's a first offence, because it allows the Health and Safety Executive to recoup their investigation costs, and also it allows compensation to be paid by courts, and you will find yourselves involved in it. By way of an example, if you have a fatality, you're talking about from beginning to end, you could have a 5-year period where people involved in your organisation, instead of doing their day-to-day work, are having to deal with lawyers. And that is costly. You will have to deal with insurers, whom you may find that if you've made some fundamental mistakes in relation to the way in which you operate your business, you won't be insured. Because insurers, by their nature, don't want to pay out. They don't want to pay your legal fees. And so often there's just not really as good practice, not because it's people just get hurt. One of the main reasons why we ought to approach health and safety law much more seriously than perhaps we did in the 70s when my dad worked on the lump is because we're dealing with people's lives, and fundamentally, because of an incident which happens, firms can go out of business, people lose their livelihoods, and that clock can never be turned back. I don't know if any of you got any questions to begin with. Anyone's got anything which arising out of the paperwork which they want to ask? It's not a memory exercise. No one's going to be tested upon it. We want you to engage, so feel free to do so. What we'll probably do is at the end of each bit of questioning, there'll be a moment whereby we'll turn to you and say, is there anything you'd like to ask? But I hope you enjoyed today, and we'll begin formally now. Thank you. May it please your honour.
Yes.
Members of the jury, I appear to prosecute in this case. My little friend Mr. Vogt, who sits over there, appears to defend. This case has been brought because of the result of an accident which occurred to an employee who was not, we say, properly inducted when he turned up for work on A.C.T. Members of the jury, if you turn to your bundle at approximately page 10, you'll see a document which is the most important document in this case. That's an indictment. That is the charge which we bring and ask and invite you to return a verdict on at the conclusion of the proceedings. The first indictment relates to the defendant Wealden Builders Limited. You will see that alleges that they contravened the requirements of the appropriate regulations, which I needn't go into detail, concerning the safety and working at height protocols. The next page deals with our client's electrical components. We say that our client did not make suitable arrangements for managing a project, and it wasn't carried out so far as reasonably practical without risk to health and safety of any person affected by the project. Why are they here? What happened is that they engaged subcontractors to perform some work at one of their sites. They were in the overall control of matters. We say they're not entitled to merely to say, let's have a subcontractor and we can wash our hands of it. We say they are just as culpable as the subcontractor who engaged the individual who subsequently was injured. But we prove the case not by speeches from here, we prove the case by evidence, and you'll hear, members of the jury, a number of witnesses who will attest to the failings by both the subcontractor and by the principal contractor throughout, before, during and after the incident took place. Those witnesses will give evidence from here. They will be sworn or they will affirm before they give their evidence. They've not come here to tell lies, we say, but fundamentally what we say is that when you look at matters in the round, you can be sure. That is the same as to say beyond a reasonable doubt you can be satisfied so that you are sure that both of these defendants are guilty. Members of the jury, we ask you not to be covered by emotion because an individual was injured and suffered brain injuries. We ask you to take that out of it. We say you don't need to even consider that because as plain as a pikestaff you will see that these two companies basically played fast and loose with people's health and safety, and they deserve to be held accountable in this court. Sentencing members of the jury will not be for you, that'll be for His Honour. And don't be scared about returning guilty verdicts just because you think that a small subcontractor may well be put out of business. They did the wrong, and we say to you that once you've considered the evidence, you will convict them of these offences, and then let justice take its toll upon them. But as I say, we deal with this case by way of evidence, therefore I call my first witness, Mr. Alan Tungate.
Mr. Campbell, before the first witness is called, I think I should say a few words about the indictment.
Please do.
Well, members of the jury, you've been referred by Mr. Campbell to the indictment, and as you'll have noticed, separate counts, count 1 and count 2, and you have to concentrate on each count separately. Count 1 relates to the defendant Wealden Builders Limited, and count 2 to Arkwright Electrical Components Limited. Now, there isn't going to be any argument about the wording of the appropriate regulations, but the words that you have to concentrate are in the indictment. And so in count 1, you have to be satisfied so that you're sure, this is a criminal case, you have to be sure that the prosecution have proved in relation to Wealden Builders Limited, that Wealden Builders Building Limited, an employer, failed to ensure that work at height was properly planned, appropriately supervised and carried out in a manner which was so far as is reasonably practicable. That's the important part of count 1. And in count 2, in relation to arkwright electrical components, you would have to be sure that that company failed to make suitable arrangements for managing a project in that it was not carried out so far as reasonably practicable without risks to the health or safety of any person affected by the project. So as I say, the law will not be in dispute, but those are the important parts of the indictment which have to be proved, and it will only be proved if you are sure that it has been proved after the evidence has been called. Thank you, Mr.
Your Honour, may I make a point of clarification
Yes.
to members of the jury? Just like to point out, for your own clarification and possibly sanity, that I will be defending Wealden Builders for the expediency of this court exercise. So, from my point of view, I'll be looking after Wealden Builders.
So I assume in relation to Arkwright Electrical Components Limited, that they've entered a not guilty plea.
Well, it'll be a sort of joint.
Indeed, Your Honour, Arkwright Builders have entered a not guilty plea, but no one, for whatever amount of money, was prepared to come here and defend them.
No, well, that won't be held against them, but the evidence will have to show that they are either guilty or not. Yes, thank you very much.
Mr. Tungate.
Mr. Tungate, are you happy to affirm?
Yes.
Could you raise your right hand, please? And repeat after me. I do solemnly, sincerely and truly
I do solemnly, sincerely and truly
declare and affirm
that
the evidence I shall give
shall
be the truth,
the
whole truth and nothing but the truth.
the whole truth and nothing but the truth.
Thank you.
Thank you, Your Honour.
Can you give your full name to the court?
Yes, Your Honour, I am Alan Tungate.
And your occupation for the purposes of today?
I'm one of Her Majesty's inspectors. I'm employed by the Health and Safety Executive for the South West.
You also moonlight as a police officer, don't you?
In a former guise, Your Honour, in a former guise.
So this may be new to you, but we'd like you to tell the truth here today.
It's something I prepared myself for.
So you're one of the Majesty's Health and Safety Inspectors. Is it correct that on around the 23rd of August of 2017, your attention was drawn to an incident which took place at Arkwright Electrical Components in Barnstaple?
Your Honour, that's correct.
And as a result of that information being passed to you, what did you do?
As a result of that, obviously, I carried out a site inspection of the venue.
Can you describe the site?
It was a construction site, obviously, which was undergoing some building work at the time. Work had restarted, but the area involved had been made secure.
Did you have any communication with anybody on the site?
I met first of all with the Eleanor Westerman from Arkwright, who was the safety advisor, and Chris Woodford from Wealden Builders were both on site.
Did you form any impression in relation to the health and safety advisor?
They answered the questions that I had at the time. Obviously, as you can imagine, my first priority was to make sure that there were no immediate ongoing risks that might have needed some action. But then obviously the second stage then was to commence the investigation into what had occurred.
Did you take some exhibits as a result of your investigation?
I have several exhibits, if you wish me to list them.
Please.
EW01.
That's at page 49 of the bundle.
EW01 was the site rules for the work on the canopy roof. They'd been signed on the 31st of July and again on the 21st of August and the 25th of August in 2017.
So looking at exhibit EW01, can you give a brief summary as to what those site rules were?
I will, and I'll say that they were fairly standard set of site rules, or a basic set of site rules, if I may be so bold. But certainly, as we would expect to see, all contractors must sign in on a daily basis, and the signing in book was checked as part of my investigation. There was the instructions and regarding the site induction and the briefing that all staff must receive before working on the site.
Please go ahead.
Indeed. So as well as the signing in process and the requirement for all staff on site to have received a site induction and briefing, there were also fairly basic instructions in relation to the wearing of high visibility clothing, the mandatory wearing of PPE, no smoking site, and the procedures for fire alarms. And then two key bits, I would suggest, obviously, the requirement for permits to work at height was established within the site rules, and that work was only to be carried out as per RAMS.
Did you also see a method statement? That's Exhibit EW02.
I did indeed, yes.
Page 50?
Yes, I've got that. Yes, this was the, again, it was from Eleanor Weston, which I have exhibited as EW02. A 3-page document highlighting the method that they were intending to employ for the purposes of the construction project.
And did you also then be given some risk assessments? EW03 and EW04, page 53 and 55.
That is correct, Your Honour, I was.
And one was an initial risk assessment, and then one was an amendment to that, is that correct?
Yes, it was, and it was signed sometime later, after the incident had occurred, Your Honour.
But these were sent to you by the health and safety advisor to the company, is that correct?
That's correct, that's who I obtained them from.
As part of your investigations, did you find out as to whether or not these documents were ever given to the subcontractors?
I'm informed they were, but whether I actually found out whether they ever were done so, no, sir, it's not something I can show.
And you also exhibit some photographs of the site, is that correct? That's page 58 onwards.
They were, yes. They were taken, obviously, from a platform looking out across the work site.
You continued your investigation and took witness statements from certain individuals, is that correct?
That is correct, Your Honour.
And you interviewed a suspect, is that correct?
I interviewed, yes, Mr. Chris Woodford.
Who was he?
He was the supervisor of the work site for the work in progress at the time. He was the arkwright.
Now, the interview is within the bundle, and that's page 40, is that correct? That's Exhibit AT01.
That's the contemporaneous notes of our interview, yes. Or the salient parts of, Your Honour.
Now, what we're going to do is we're going to read this interview. If you can take the... you can read your questions, that's AT, and I'll respond in relation to Mr. CW. But before I do so, ladies and gentlemen, this is an interview. Now, you'll know that interviews are conducted by prosecutorial authorities and inspectors, such as Richard and his former guys. You will have seen them on the bill, you will have seen them on a variety of different television programmes. An interview by any authority is nothing more than an evidence-gathering exercise. They will say to you, if they're investigating you, that, oh, it's in your interest to put your side of the story. Yes, there is a duty to cooperate with the Health and Safety Executive and other agencies, but they are prepared for that interview should they conduct one. If you're being interviewed, the likelihood is that you may not be prepared for that interview, despite the fact that you think you are. Interviews are a little bit like cross-examination. Women are better at them than men. Why is that? Well, those of you who've been on the end of a good telling off from your other half, who may be female, will know this. First speaking statement. A man comes home from the pub. He told his wife or his partner or whatever he would be home at 9. He doesn't come home until 11. What a woman does is ask a question. But then women use silence. The man doesn't think he's answered the question, so therefore goes on and gives more information, which digs a bigger hole for them and gets them into more trouble than they were when they first came home. Later on, when you go home this evening, ask someone who you know, ask them to tell you, do you know what time it is?
24 to 10.
That's not what I asked. The answer to the question, do you know what time it is either yes or no. What our friend here did was the obvious thing, which so many people do, and give more information than was actually requested. Try it. It works. But when you're being investigated, or you're being interrogated because you've done something wrong at home, or whether you're subject to an investigation, or teaching people how to deal with authorities who want to investigate for problems in a workplace, use that skill. Use that one question, because it makes the recipient then think, ooh, why didn't I just answer the question which was being asked? As I said, these are evidence-gathering exercises by the prosecutorial authority. They're not on your side. Now, you stand back and you go, but that's not fair. You know, someone's been injured. It's right that someone is held accountable. Well, that's for society, and that's for the decisions to be made further down the line. When you are the person who is being investigated, your lawyer, and your job is to look after yourself. Not to lie. I never say to anyone to lie, but think before you answer a question. And if silence is used, it doesn't mean that you haven't answered the question which has been asked. It just means that they're probably trying to lull you into the opportunity to fill that gap, to fill that silence, and say something which perhaps you didn't really want to say in the first place.
Do you think it was safe?
Oh, it was 100% safe. Well, the next thing I know, Derek had gone through the roof and was on the floor.